Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy, powered by TrustArc. Here are your hosts, Paul Breitbart, Ralph O'Brien, and Dr. Kay Royal.
So we just continue the conversation that we were having right before I hit record, but Kay and I were talking about whether or not we know things. And the bad thing is, and that's also one of the things I discussed with students last week, the more things we know about privacy and data protection and AI and digital services and all of the digital stuff that you hear us talk about, the more we also know what we don't know.
Exactly.
But that said,
we don't think
we
know
are
it
still
all.
convinced that we know a lot.
We know a lot. We know a thing or two. We drink and we know things. And I'm sorry, y'all. I really don't watch Game of Thrones. That's like the only quote I know from that. I think that's from Game of Thrones. But yeah, we don't think we know everything. And the best privacy people, the best lawyers, the best professionals in any of the actual true professions know that's the first thing they know about their level of knowledge is I don't know it all.
And it's okay to
The
doubt.
minute you think you do, maybe you should run for president.
Or just shut up. Did I actually say that? Yes, I did. My name is Paul Breitbart, and my name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. We're just going to jump right back in on, what do we call this? The original programmatic format? Paul and I just tossing out gems of wisdom as we go. Okay, so here is the unexpected question. Ooh, what has taken you the longest to get good or decent at? And if he says cooking, it's a 50-50 with privacy, right? Or
You get good, decent at. In line of what we were just discussing, it is probably privacy, because it's taken me the better part of 16 years to, okay, I will admit, I'm good. I think I'm good. I'm beyond decent, let's say that. But I'm far from perfect.
I'll go for that.
Is that acceptable?
That is acceptable because you wouldn't start a podcast, a global podcast that is listened to in over 200 countries for something that you're halfway decent at, right? You have to at least be good at what you're doing. If not, it would never succeed. It would never win awards. It would never consistently be recognized as one of the top privacy, data protection, cybersecurity law podcasts
And
in
we
the
wouldn't
world
have
if
6
we didn't know
seasons
what we were.
almost wrapped up.
This would have gone away long before that. So we know what we're talking about. Are we the best? No. There are so many professionals out there that are my privacy, data protection, cybersecurity law heroes. It is absolutely ridiculous. We've had a lot of them as guests on the podcast. Yeah,
more
there's
to
a
come.
lot of people out there that are my heroes. Dan Solov has been a hero of mine for a long time. Absolutely
So what are you
adore
good or
them.
decent at?
I was going to say,
That
my
took you
answer
a
will
long time.
surprise you. What took me a long time? Makeup.
Okay, I'm not good at that at all. Happy to admit.
I was one of these people that just, I never really learned how to do makeup. I didn't wear makeup to school as a child. I was not good at it, but I've had to learn it being in pageants. And I just had some photos, and I'll share one of these photos with you. So I shared this photo. Let me see if I can hold it up to the thing for Paul. I shared this on Instagram yesterday. This is not touched up. This is good photography and good makeup, which I did not do. But with the people's comments on them, I had to make the remark that I think I'm a late bloomer. I didn't even wear makeup to school in high school. I didn't know how to do eyebrows until I started pageants, which I was nearly 50, and I'm still not good at doing eyebrows. And no, I don't
So you
do
mean
them
there's
here.
still hope for me doing makeup?
There is still hope for you doing makeup.
Okay.
I was gonna say my answer would probably surprise me. It took me a really long time to get good at doing makeup, but I actually am decent at it now. Not that I bother showing those skills off with you when we do the podcast, which is why we don't do a YouTube or a LinkedIn live recording of them. Although, if we did, I promise you I would show up either with a makeup app that would do the live vid or I'd put makeup on.
Okay, talking about Pretty Woman,
Thank you. He's like,
you're
"Not you,
welcome.
Kay."
This is both a reference to what you were talking about, but also to the movie. There is actually a case from the Court of Justice of the European Union that I want to highlight, and that is the Russ Media Digital and Inform Media Press case that came out on the 2nd of December, 2025. And this is a case about an online marketplace which allows digital advertisements. So anyone could just put an ad on the website, either for free or for a fee. This is a website from Romania, and this is about the sale of goods, but also the provision of services. So on the 1st of August, 2018, an unidentified person published an ad on the website stating that a certain woman was offering sexual services, including her phone number and some pictures. And the woman considered that the advertisement was false and harmful, and therefore went first to the website asking to remove it, which was done. But the ad had also surfaced on other websites where it remained accessible, so it was copied over. Typically somebody trying to hurt the woman. That so much was clear. So she went to court. The court of first instance upheld her claim, ordered the Russ Media Digital to pay her damages of 7,000 euros. On appeal, the company was actually exonerated. And then in the final instance, the Court of Justice of Romania, they looked to European law and also went to the Court of Justice of the European Union, asking, first of all, whether the EU Liability Directive would offer some help here, but also looking at GDPR. And the Court of Justice of the EU now found that the provider of the online marketplace is in fact the data controller of all the information, and that they have the obligation to verify whether the personal data contained in advertisements published on the marketplace are being processed in line with GDPR, meaning that the person whose personal data is processed, picture and the phone number in this case, had actually provided consent, or whether another legal basis would apply, before publishing the advertisement. So they have a duty to verify and identify the information,
The
especially because
platform
it's
does,
sensitive
or the
data.
company posting the ad does?
No, the
Sorry.
platform does. The platform
Okay.
does. And that is the important thing here. That's the novelty. The platform has that responsibility, and that goes beyond the individual posting. So obviously the individual posting has an obligation as well, but the platform also has an obligation to verify whether the individual has the right to publish that data, whether it is the person
Interesting.
whose data it is publishing the ad, or a third party. And if it's a third party, then the explicit consent would be required.
Right.
And the court also has confirmed that the operator of an online marketplace cannot avoid their obligations under the GDPR by just relying on a liability exemption in the liability directive. So they may not be
Or in
fully liable
contractual
under,
liability.
they may not be fully liable under contract. They are liable under GDPR, and they are a data controller, which is a very important step. I think for me, not immediately a novelty, because I've always considered for our online
Right.
marketplace that we would be data controller. But it's good that the court confirms this, and this obviously also on the online marketplace that I work for, you will not find personal ads like this. You will only find objects on sale that are offered through us, but that also have been curated. So all the information is already verified before it is posted, and a lot of it is indeed also refused. But it is
Right.
interesting to see that the court now is so clear about the role of an online marketplace as data controller.
So what I was thinking about when I was looking at that, which I have to admit, I didn't look at it in detail. I just skimmed an article summary of it, was I'm not sure you would have gone into it knowing which way the outcome would be, or it wouldn't have gone to court. But if it was in the US, I have a feeling we would be leaning heavily towards a different outcome, because there's the third party doctrine here, and that private parties and all this good stuff. We're not going to go into a legal lesson about that. Let's just say the laws are different. And I'm not sure you would have had the same outcome if it had been a case here in the US. Of course, we don't have the GDPR, but you could very easily put it under a HIPAA case, or a FERPA doesn't really have a lot of teeth. A Privacy Act case, you could literally put it under a whole bunch. You can put it under California, the CCPA, and look at that, and then look to see if you would have a similar outcome about whether or not companies subject to CCPA, like most of the big tech companies that are in the news are, would they be responsible for ensuring that the ads placed on their forum are compliant with privacy law? And probably not. They would push the liability off on the companies,
poster.
the vendors, the whoever, the clients who would be placing the ads. And I think most people familiar with US law would say, yeah, that's probably true. But should that continue to be true? That is so well ingrained in our legal system. Now that we have omnibus privacy laws on a state-by-state basis, would that be something that you should hold third-party platforms responsible for the material put on their website, and whether it's ads or not? And I'm thinking of the Supreme Court cases about the ISIS recruiting. I think it was both Twitter and Facebook that had those cases, or Twitter had a similar one. And the court came out and said, no, they can let whatever they want on their platform and they're not responsible for it because,
Sure, but
there's
that would more be a
there's
freedom
no
of
law
speech issue,
against
right?
it. Huh?
That would be more a freedom of speech issue given the types of platforms
Kinda,
that we
but
are talking about.
I was going to say, but freedom of speech applies to government.
True, but this would probably be more comparable to a Craigslist or eBay
Okay.
or maybe even Reddit, where you can post messages of services you
And
offer or
see,
things you
and
have on sale.
Craigslist, Angie's List, whatever, Reddit would not be responsible for companies that place advertisements in their paper. Maybe if it's
Yeah.
for something clearly illegal, like slavery, maybe there would be something there they could choose not to publish it or not.
I guess in many US states, sex work is illegal as well.
Yeah, but they sure as heck wouldn't say, no, you can't do it because of privacy. Now, here's the thing. If someone did have an ad, and this is where we do have the privacy cases of using the likeness. Now, California has these laws, the likeness cases, which are like an invasion of privacy. You can't use someone's likeness, their voice, their appearance for things, but that wouldn't be under omnibus privacy laws, and it sure as heck wouldn't be against the platform hoster. It would definitely go against the company who made the ad and placed the ad. The liability would be on them to make sure that they had legal authority to be able to place the ad. So interesting outcome. That's a good one to get into a debate with later about right or wrong, but right or wrong comes down to one, morals, ethics, and then the law that may apply, and the law is different.
Yeah, no, I think so. And obviously this Rusmedia website is only active in Romania, or at least as far as I'm aware.
Right.
So impact would indeed stick to what is happening in the European Union. But it's an interesting case, and it's certainly a decisive case on the application of the legislation. Another thing that has been happening is that the ICO has offered or has issued another reprimand. This case to
Say it's
the
not
UK.
so.
Oh yes, the UK Post Office Limited this time have received a reprimand following a data breach. You may be aware with the whole post office scandal that has been happening in the past decade. And there has been an ITV TV series made out of that. It's been a big scandal. Basically, think about 10 years ago, the UK Post Office introduced a new IT system that didn't work. It cost a lot of people running post offices, so the postmasters across the UK in small shops. It cost them their income. It cost them their sanity. It was a serious issue. At some point, a settlement was reached with over 500 people who were part of a group litigation, but the settlement document included names, home addresses, and their postmaster status, which was publicly accessible for 6 weeks in 2024 before being removed following the notification from a law firm. So it was not only fold upon fold, but then also a data breach at the end of it. And the ICO has now found that the post office actually failed to implement appropriate technical and organizational measures because the document was publicly available, but there were also insufficient documented policies. There was no quality assurance. There was actually a fine that has been considered of up to £1.094 million, but the ICO considered that a reprimand would be sufficient because the threshold of egregious under its public sector approach has not been met. So in principle, the ICO still has the stance that in the public sector, they won't impose a fine unless something is egregiously wrong, which in this case apparently was not the case.
I like egregious. I like that standard. I'm not going to disagree with that.
I'm not sure, given
Ooh.
the whole issue here that's at stake and the whole history of the post office scandal, I would say this is fold upon fold upon fold, and maybe a fine here would actually have been in order. You cannot just look at this without the context of the whole scandal. And it seems that somehow they
Well,
still
that's
have
true.
done that. So I may have made a different choice. What I do like about this press release from the ICO is that they actually put in lessons learned for all other sectors to learn from. So things like
Yes.
that you need clear publication protocols to make sure that you keep things confidential that need to be confidential, and that you need to understand the data that you handle, that you need to classify documents, including on online storage systems, and that you should avoid personal storage systems.
Yeah.
Those kind of things I think are useful. Maybe they're still a bit generic, but it can be helpful if you are an organization looking at, okay, so what does this mean to me?
Yeah. And we've been asking for that for years.
Yeah, I think that's something data protection authorities could do much more.
Exactly. That we can carry forth and we know, oh, we can't do this, but we can do this, or we shouldn't do that, or this is our standard. I like the egregious standard. It's pretty clear cut, even though there's probably not an exact definition of egregious, but it's like pornography. You might not be able to define it, but you know it when you see it. Egregious, reasonable, those are good standards to go by. I might
Yes.
not have really applied. I'm with you. I might not have really applied the egregious standard to this, but they applied a standard and
Yes,
they gave
definitely.
guidance. And that's what I like. I like that they put their foot down. We've criticized them. Well, we've also applauded them over the years for good things and criticized for bad things. Of course, Ralph isn't here. There'd be a whole lot more criticism there going on. But I like the step forward, especially the giving the lessons learned, the guidance to other companies to know what can I do or not do, because that's one of the things I despise about our not recent even, it's been for years, decisions on privacy through the United States Supreme Court is we don't have clear guidance. And of course, then when we do have clear guidance that stands for decades, it gets reversed. But otherwise, all the ones in between, we just don't really have clear guidance on. We know that if we want to be a fireman in California with the pager and we use it for personal use, that's not a violation of privacy. You're allowed to fine me for using my pager above the company limits or whatever the case may be. But you don't have any guidance outside the exact facts of the case to be able to say, oh, but what about blah, blah, blah technology? Or how would we address a situation like this in the future? And that's what, to me, the laws and the regulators are for. The laws cannot be precise. We see a lot of current technology that is being rolled under old laws, like wiretapping laws for cookie tracking, because laws cannot be precise. You have to look at the meaning of the law, but you rely on the lawmakers, the courts, the regulators, to actually put some context around it and some guidance. Now, again, that's another thing that also went by in the United States was the regulators getting default preemption or respect for coming up with expert opinions on unclear laws. But that aside, that's what I'm for, right?
Yeah, but there is also a job here for the legislator themselves, because legislation should be clear. You should be able to read legislation as a standalone document and understand what it is that you are expected to do or not do.
Really? When the law was written 100 years before the technology was even dreamed about, you expect the law to be clear on it?
No, but I do expect the legislator then to be realistic enough to add to the law or to update the law.
We're not even clear on the Constitution.
Well, no, that's because you have a very messy system with all the states and the Constitution and all of that. But if you look at legislation that's being drafted today in the era of tech, then I would expect that legislation is clear.
Yeah, but if they write it specifically to the tech in 20 years, it's not going to be clear.
No, I know, but even today, that's my issue. We've spoken about the digital omnibus before it came
Yeah.
out during our live and privacy space. But if I read now the final version of the text, it's such shoddy legislation. Provisions are unclear. It's unclear how they relate to each other. It's not well written. It's not well thought through. If you look, for example, the European Union has tried to, or the Commission in their draft has tried to codify the definition of what does not constitute personal data following the SRB case. We spoke about that in privacy space. But if you now look at the final text, one of the questions that you can easily ask, and it's actually Simon Hania who asked it during an FPF Live that I participated in on LinkedIn, he said, well, if a company says, oh no, but this is not personal data according to the new definition, and you disagree with that statement and you consider it is personal data, who do you go to challenge that?
Who do you go to?
Are you still able to go to the supervisory authority, or are they not competent automatically because the non-applicability of GDPR was invoked already? Can you go to court because you don't agree with a negative? It's completely insane how they've drafted this without looking at the context again. And as I keep telling my students as well, context matters also for legislation.
Context matters.
So this
It
is not
does. It
something
matters.
that will be outdated in 10 or 20 years' time. This is something that is not useful right now, that is intended to make lives of companies easier. And it doesn't.
You know why I'm laughing, right? One, this is like the number one way to get Paul riled up. I love it. But two,
Sorry.
it reminds me of the CCPA when it was first released.
Guess
Remember how bad that was? This is not quite on that level. We now have our bar. Original CCPA. So it's not quite there.
luckily this is not the final text, and there's a lot of negotiations and amendments.
That is one thing I appreciate about the Europeans, is taking the time to get the iterations correct and having those conversations. And then finally, after, I don't know, 5 or 7 years, deciding you're not going to pursue it because nobody's ever going to agree. Hello, e-privacy regulation.
Yeah. My mind is a little fried after a day of teaching and working. But earlier today, I mentioned to my class that I would start lobbying for an additional amendment in the GDPR to be included in the digital omnibus. I just can't recall which one it
Ooh.
was, but when I go back to my slides, I'll probably find it again and can draft it.
That would be good. This kind of reminds me of, or not reminds me, makes me think of legislators who actually care enough about the people that the law is going to apply to, going out and learning what do the people care about, what kind of repercussions or consequences could there be, what's the worst possible thing that could happen, and the most reasonable step you can take to prevent it. My children hate that piece of advice, but it's legit. There are legislators out there who care, and in Europe, y'all have built that into your legislative process. I don't think we've built that into our legislative process here. There are agencies that will have listening tours, or when they're looking at passing regulations, they will have comment and answer periods and things like that. And they're required to go through and publish every comment and their reaction to each comment, why it did or did not make it into it. But the law itself, no, not really.
Yeah, I think
not
sometimes
really.
it's needed to do that. And you know that GDPR is one of the most lobbied pieces of legislation in European history. And I don't believe that the digital omnibus, will be any different. I also don't expect this to be law anytime soon. The funny thing is, together with the digital omnibus, the Commission also published a draft for a digital AI omnibus, which would push back
Right.
some of the dates in the EU AI Act on when certain provisions would apply. The funny thing is that the first deadline that will be pushed back is the 2nd of August 2026. And Somehow, I have a very hard time to believe that this law will be adopted in 9 months' time and in the official journal.
In time to actually do it. So what they might do is just suspend enforcement. What do you call it? Not casually.
I really don't know. And can you still push back a deadline once something has already entered into force? When provisions enter into effect on the
Right.
2nd of August 2026 and say by December
You can bless them
2026,
in
you reach agreement,
retrospect.
it would be strange, right? To undo the application of a law that has been
The
in
only thing
application
I
5
can
months.
think of is if there's any enforcement action that has taken place, any complaints, any whatever that has taken place. So if you don't pass it until June of 2027, you could go back and erase all of the enforcement action, just say all of these are thrown out. We're delaying the whatever, but
But you're only delaying. It doesn't mean that the provisions will never apply. So
unofficial. That's what I was looking for. Unofficial.
I think it would be a really strange situation if you go and retroactively postpone legislation that has entered into effect.
Oh, come on. We do it over here all the time. Okay, we probably don't do it all the time. But I bet I could look up some examples of major legislation that passed the active date and retroactively suspended the
Postponed.
go live date. I'm thinking HIPAA probably did that a time or two. Hopefully you're not hearing the pups bark. But I think HIPAA may have done that a time or two. I bet I could go find some examples. I think when it comes to data protection and privacy law, this isn't going to be the first time we're going to see something like this happen in Europe or LATAM or Asia Pacific or North America or anything. These are just going to get to be more complicated pieces of legislation that are going to try to pile on a lot of other legislation that kind of fits in and mash them all together and try to come out with some clear-cut way of proceeding through managing personal data.
Then let me make a clear call to the legislators around the world. Make sure you draft proper legislation that people actually understand, that is useful both for people, for individuals, and for companies and other organizations, instead of just doing something because you feel it might work.
Well, and also get your federal and your local lined up if that's an issue where you are. If you're in a region or a country that has states or different things like that, try to get the bigger picture to align with the smaller picture. I'm not sure that can ever happen. We have a lot of guidance. We're going to do a special episode on this is how lawmakers should actually pass law. These are the clear-cut constitutional guidance on passing law. Heck, when I go to a company, one of the first policies I look for or make sure is in place is the policy on policies. Now we need a law on lawmaking.
Yeah, like we have the Vienna Treaty on treaty making that actually exists.
There's pre-existing examples for this. We can easily come up with, here's your checklist of what you need to do to pass a law, other than the Schoolhouse Rock, I'm just a bill, I'm only a bill. I'm sitting here on Capitol Hill, and I won't sing anymore, I promise y'all. But yeah, better guidance than I'm just a bill.
Yes. Do we have anything groundbreaking happening in the US this week?
Not that I can think of. Yeah, that has nothing to do with the White House. I would say if we look back over November and what we saw over November happen, I wouldn't say that there was anything really groundbreaking here that made me go, ooh, that shouldn't have happened.
State legislation has pretty much dried up for the year, right?
Yeah, you're not going to see a lot of things pass through in the next 3 weeks. There was the education software company, the New York AG, had a $5.1 million multi-state settlement with the education software company. I don't think we talked about that one before. And also a $14.2 million settlement with car insurance companies, which I think we quit reporting on because there's been so many enforcements and settlements around the cars that we have that. So we didn't have that. There were some, I don't know that they're not enforcement, some announcements around frameworks and different things, but not necessarily here in the U.S. I think there's been some movement around the world on the use of frameworks. Like California, I think, spun up a data broker task force or whatever built around a particular framework of how they expect their data brokers to work. So we'll see a lot of information coming out from that. And I think there's been some movement globally to try to stabilize on a set of rules, just like rules to pass laws on how to actually run different types of industries around data. And I think that if I had to make a prediction, and we should probably do this by the end of the year, we also have to do the state roundup law case. But I would predict that standards and frameworks are going to become much more important.
Yes, I think that is fair.
And a natural reduction to a centralized framework that is pretty globally applicable. I think
So I
we'll
have
see
to
more
in
movement in
mind
that
that
direction.
one of the frameworks, that's actually a treaty, but would be the Council of Europe Convention 108 Plus, because that's the only
Yep.
binding instrument on data protection that could apply globally at this time. But if you talk framework, my mind immediately goes to the NIMIDY framework, of course.
Yeah. A favorite of every privacy and data protection person ever was the NIMIDY framework, which TrustArc has done a really good job building into their platform because TrustArc had a framework as well. It doesn't make for a pretty printout.
The TrustArc framework, with NIMIDY still does.
Yeah, but I meant the NIMIDY within the TrustArc didn't make for a very pretty printout if you tried to make a combined one. Trust me, Paul and I worked on it quite a lot as well. It doesn't. But if you like the NIMIDY framework, it's still available there, and a lot of data protection and privacy people still go by it.
Yes. And speaking about that, if all goes well, next week we will have a team from TrustArc joining us to talk about a few things that are happening within the company. Always nice to have our sponsor represented. So stay tuned for that.
Yes.
We'll promise you it won't be only product pushing, because that's not what we do.
We don't do
but
that.
we look forward to hear more about the changing vision of the company.
Yes, I think that's going to be fantastic, with the default position being they're now going to focus on Europe and the rest of the world outside US and Canada.
Exactly. So you'll hear more about that next week. Until then.
Ciao, babies.
That was Serious Privacy.
This wraps up our podcast for this week. Please do share the episode with your friends and colleagues, because we love to get more listeners. And join the conversation on LinkedIn or on Blue Sky. You'll find us under Serious Privacy on both platforms. You'll find Kay as Heart of Privacy, Ralph as IGR O'Brien, and myself as Europol B. Until next week, goodbye.
Goodbye.
Bye, y'all.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMIDY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.